Hello, good afternoon. My name is Rich Ting. I'm the president of APABA-PA. I wanted to thank all of you for joining us today for our annual banquet. I'm sorry that we can't offer you the huge meal that we usually have, but we do have a very interesting program lined up for you. I wanted to acknowledge a few people first. First off, Susan Lin, who is APABA-PA's banquet chair. She planned this event, so big thank you to Susan. And also a big thank you to our speakers, Neal Katyal and Karen Tani. They will be having a fireside chat, and that will be followed by a presentation of the Marutani Fellows and our Attorney of the Year. So congratulations to those folks. And as you may know, this is typically our biggest fundraiser of the year. It primarily supports the William M. Marutani Fellowship, which is a fellowship that provides financial support to law students in Pennsylvania and the greater Philadelphia area who are doing summer public interest work. And I also finally wanted to thank all of our sponsors. You may have seen the sponsors' names on your screen. They're also listed on our website. And I wanted to particularly acknowledge our gold level sponsor, Exelon Pico, and our main sponsor, our pearl level sponsor, Comcast NBC Universal. And with that, we have a message from our main sponsor, Comcast NBC Universal, and that is from our representative, Jasper Kakananta. So I'll turn it over to Jasper.
Thanks, Rich. Good afternoon, everyone. My name is Jasper Kakananta, and I am here representing Comcast NBC Universal. On behalf of the company and my colleagues in the Comcast legal department and our diversity committee, I wanted to congratulate APABA-PA on their 37th year as an organization and to this year's 2021 Marutani Fellows. We are honored to be the pearl sponsor of this year's annual banquet, and our supportive groups like APABA-PA is it's a major part of Comcast's continued commitment towards diversity, equity, and inclusion in our legal profession. As Rich said, hopefully we can all see each other in person for the next annual banquet. But I'm excited for this afternoon's event and keynote speaker. Personally speaking, I am one of Neal Katyal's many Twitter followers, and I always find his observations on what is happening in our country and in our government to be very insightful and interesting. So I'm looking forward to Professor Tani leading what should be a very engaging conversation with Neal. Thank you again for the opportunity to sponsor this event, and I hope you all enjoy the rest of the program. Now I'm handing it over to Susan, who will introduce our next segment.
Good afternoon, everyone. So as Rich said, my name is Susan Lin. I am this year's Vice President of APABA-PA, and I am Chair of the 2021 Annual Banquet. And I am incredibly excited to be able to introduce our guests today. Of course, Neal Katyal. Neal is the Paul and Patricia Saunders Professor of Law at Georgetown University and a partner at Hogan Lovells. He previously served as Acting Solicitor General of the United States. He has argued 45 cases before the Supreme Court, with 41 of them argued in the last decade alone. His cases include successfully striking down the Guantanamo military tribunals, successfully defending the constitutionality of the Voting Rights Act, successfully defending the Peace Cross in Maryland, and a landmark personal jurisdiction win for Bristol-Myers Squibb. At the age of 51, he has already argued more Supreme Court cases in US history than any minority attorney, recently breaking the record held by Thurgood Marshall. His numerous distinctions include the Edmund Randolph Award, which is the highest civilian award given by the US Department of Justice, the Litigator of the Year Award by American Lawyer, the Appellate MVP by Law 360, Financial Times Innovative Lawyer Award, one of GQ's Men of the Year, and many more. He has appeared on virtually every major American news program and on Stephen Colbert's Late Show. And he has also played himself on Netflix's House of Cards and Showtime's Billions. We are honored to have Neal join us today. Neal will be interviewed by Professor Karen Tani, a Seaman Family University professor at Penn Law School. Professor Tani is a scholar of US legal history with broad interests in social welfare law, disability law, administrative agencies, and the role of rights in modern American state, the modern American state. She teaches torts, American legal history, and law and inequality, and she has a joint appointment with Penn's history department. Her book, State of Dependency, won the 2017 Cromwell Book Prize from the American Society for Legal History. She has had articles published or forthcoming in the Duke Law Journal, the Cornell Law Review, Yale Law Journal, Michigan Law Review, Law and History Review, the University of Pennsylvania Law Review, the American Journal for Legal History, and Publius, the Journal of Federalism. We are grateful for the participation of both Neal Katyal and Karen Tani. Now, a couple of housekeeping matters. If any audience members have questions for Neal or Karen, please use the Q&A function. Type your questions into the Q&A function, and Karen will be monitoring the Q&A throughout the interview. And also for those who are signed up for CLE credit, you must stay through the end of the program and answer the poll at the end. If you do not answer the poll, we will not be able to get you CLE credit. And now I turn things over to Karen and Neal.
Thank you so much for that introduction. Thank you to the organizers for including me. I am absolutely thrilled to be here. I wish, of course, that we were in front of a real fire for this chat, but it nonetheless is such a pleasure. Neal, looking across your work, I mean, there is so much that we could talk about. So I thought maybe it would be best to start thematically. So some of the work that you are most known for is at the intersection of national security, executive branch authority, and the legal treatment of disfavored groups. So I'm referring, for example, to your 2006 argument before the Supreme Court in Hamdan versus Rumsfeld, which considered the legality of military tribunals in Guantanamo Bay. I'm also referring to some of your work as acting Solicitor General. So in 2011, you famously issued an apology on behalf of the Department of Justice for its handling of the Korematsu case. So you, in a confession of error, as it's called, you acknowledged the department's suppression of critical evidence, which in turn made it easier for the Supreme Court to essentially uphold the legality of the forced evacuation and relocation of over 100,000 Japanese American citizens during World War II. And then most recently in 2018, you argued Trump versus Hawaii, involving the travel restriction that is commonly referred to as the Muslim ban in the media. So I wanted to ask you, just looking across these cases, and of course, feel free to include other examples that I haven't mentioned, what do you see as the relationship between, on the one hand, concern for national security, and on the other, animus toward particular racial or ethnic or religious groups? Is there a theme that you see running across these cases? Do you see these contexts as distinguishable?
Okay, so first of all, it's a real honor to be here. I wish we were doing this in person, obviously, but this is an organization I care a lot about, and I care about these annual meetings and having them in person. And so I understand why we're not, for all sorts of great reasons, but it's a great organization and a great event. So I'm happy to do it at half strength virtually. And Karen, it's a real delight to be here with you. As I think you know, I've been a fan of yours ever since that Yale Law Journal piece you wrote almost a decade ago. And we both clerked for the same judge, for Guido Calabresi. So I don't think we've done an event together before, so it's really fun. Okay, so to answer your question, there is a theme to all of this work. And the theme is that executive branch lawyers have a special responsibility in national security cases to be totally straight with the facts in the court. That's true generally for executive branch lawyers, but there's a little more advocacy if you're like, I don't know, defending the constitutionality of a piece of legislation or something like that. The court expects zealous advocacy, and whether if you're pushing a precedent beyond what it's worth, everyone can read the precedent and say, oh, you're stretching that precedent too far, you're stretching McCulloch versus Maryland too far or whatever. That's all open source for everyone to see. The problem in national security cases is that the evidence is often only held by one side, and the other side really can't ever get access to it, or maybe they can through a complicated CIPA, Classified Information Procedures Act substitution process, get some of that evidence, but really they don't get it. And the court is always composed of 9 generalist judges who have no access to intel information, no real understanding of how to process it anyway, even if they had access to it. Yes, they have security clearances, but that doesn't really get them what they need, which is they don't even know what to ask for. And so it's all up to the executive branch in all of these cases to be straight with the court. And the temptation as an advocate, particularly when there's a national security crisis, and of course there was in World War II, of course there was after September 11th. I don't actually think there was one with respect to the Muslim ban, but I think that was concocted. But nonetheless, I think the temptation as an executive branch lawyer is preserve executive branch flexibility. Win this case. Don't let the courts straitjacket us in any way. And so there's a tendency of the executive to try and push the advocacy limits beyond what they support. And that's a natural thing. It's just fundamentally wrong. And we've seen the consequences of that most powerfully in Hirabayashi and Korematsu. I mean, these are cases that I think all of us read in law school, but at least the way I was taught it in law school, it was the Supreme Court's fault. They got it wrong. And I certainly think the Supreme Court got things wrong in both cases, particularly in Korematsu when some of the gig was up. Hirabayashi came first. It was decided unanimously and deferred to the executive's belief that the national security threat was real and that restrictions on Japanese Americans had to happen. And that's an odious, terrible position. I don't care what, I can't actually imagine a constitutional justification under any means for it. But you're in the middle of a world war and the executive branch is saying, we need to do this. And the problem was that there was evidence, the main bulk of the intelligence evidence at the time said, we actually shouldn't do this, that this is motivated by prejudice and racism and wouldn't get us anywhere. And the government hid all of that, even though there were young assistants in the Solicitor General's office that told the Solicitor General, this is all wrong, this is all lies. This is, if you don't tell the court the truth, this will, quote, approximate the suppression of evidence. That's a quote from the files. And yet the Solicitor General did it anyway. And whatever you might think of how he did it in Hirabayashi, he did it again in Korematsu. And 6-3, I think the decision was to say that the national security threats were real. And so I think that really highlights the stakes of executive branch lawyering in national security cases. And you just got to be absolutely straight. So in Gitmo, I really did feel like that at the end of the day, that yes, there was obviously a terrible threat posed after September 11th. Gitmo and the idea of creating a legal black hole for these military trials was not going to get us anywhere on national security. And fortunately, the court agreed with that. And then we had the Muslim ban case, which came out the other way. And that's one in which first the president, that first weekend after he was inaugurated, and I think all of you remember those scenes at the airports, said, issued this ban right after he had campaigned. Like he gave a campaign speech saying, quote, I, Donald J. Trump, are calling for a complete and total shutdown of all Muslim immigration to the United States. And he later said, quote, Islam hates us, and things like that. And so then he issues this executive order, which bans travel from 7 countries that are overwhelmingly Muslim, like 90.9% to 99.9%. And so the first one got struck down by the ACLU and folks in Washington State, which was awesome. They ran right into court while people were at the airports, got that struck down. Trump freaked out, said, see you in court. I'm taking this up to the Court of Appeals. But he got scared and pulled it back. And then he had a second travel ban, which we knew was going to be like the first one because his advisor, Stephen Miller, kept on going out to the camera saying it's going to be the same as the first one. So we basically we wrote a complaint for the state of Hawaii, which basically said, hey, this is the same thing. And lo and behold, it was and so we were able to go into court within 4 or 5 hours of issuing the new one. And really say the only difference was that Trump had added the country of Chad, which I think Trump thought Chad was some guy. But in any event, so we won that, got that enjoined, Trump freaked out again, attacked the judge, so-called judges, this and that, said, see you in the Supreme Court, like, bring it on. So we go up to the Supreme Court, and 2 weeks before the oral argument, Trump got scared again, pulled it back, and then issued Travel Ban 3. And I'll stop the story after this, but Travel Ban 3 was a little different than Travel Ban 2. And it allowed him to go to the Supreme Court and say, cancel the oral argument on Travel Ban 2, which they did. Travel Ban 3 added 2 new countries. It added North Korea, because we have an overwhelming immigration problem with North Korea. And it added like 100 people in Venezuela who worked in the travel office and who I don't know that had any desire to ever come to the United States. But in any event, it allowed Trump's lawyers to say with a straight face, oh, we're not discriminating against Muslims, because it also reaches these other folks too, and it doesn't use the word Muslim in the text of the order itself. And I thought we had the killer answer to it, and Justice Kagan, I think, picked up on it at oral argument. She said, look, if on Monday the president says, I hate Jews, on Tuesday bans immigration from Israel, I don't think on Wednesday he's allowed to say, well, it doesn't say the word Jewish in it, so therefore it doesn't discriminate. We all know what's going on. And we all did know what's going on. And, I'm 100% confident that once the records are shown of what this executive order is about, if Trump didn't try and burn them all down and, have bogus claims of privilege, I think we'll see this for what it is. And I have no doubt that a similar confession of error will happen at some point in the future.
I have a couple of follow-up questions about Trump versus Hawaii. So one of them is my own, and one is coming from the chat. So the question that I wanted to ask you, and this brings us sort of full circle, is that the majority in Trump versus Hawaii took the occasion to specifically repudiate Korematsu, which, as you said, has become sort of anti-canon in constitutional law. So I wondered what your reaction was when you saw that in the majority's opinion. And then the question from the chat that I'll bring in, this is also about precedent. So, and this is a case that I know less about. The question is, does the Supreme Court's reliance on Mandel versus Kleindienst rational relationship standard in Trump versus Hawaii mean that all future challenges to national security orders will be held to that low level of scrutiny?
Okay, so with respect to your first question, I actually wrote about this in the Yale Law Journal, because my first reaction was, obviously, I was happy to see Korematsu overruled finally. Yes, Judge Patel on the district court in California did kind of overrule it by granting an in coram nobis petition based in part on these lies that I'm telling you that the Solicitor General told the Supreme Court. So that was good to see, Judge Patel's decision, but much better to see the Supreme Court take back, as opposed to a district court, what was said in Korematsu. So that's the good side. The bad side is, and this goes to really the second question, have they just resurrected Korematsu by a different name? So now, Justice Jackson famously in the dissent in Korematsu said this principle is going to lie about like a loaded weapon for some future president to pick up. Now, is that loaded weapon just called Hawaii versus Trump as opposed to Korematsu? Have we really gone anywhere doctrinally? And it's not clear to me that Hawaii versus Trump is any better than Korematsu. It stands for the same basic kind of rational basis deference. It has its roots in kind of the Curtis Wright case that the government always cites, which is, also colloquially known as, instead of Curtis Wright, the government is always right case. And look, I think there's an important need for the court to defer to the executive on national security issues, because as I was saying at the outset, they don't have access to all the intelligence information. There are going to be true threats, and it's great. I celebrate the idea that the ACLU and civil libertarians bring these lawsuits. I think that's good to check the executive branch, but the CCR and ACLU and those types are never going to have the full intelligence picture. And sometimes there's going to be a need for things that are hard, and we can't always just have courts, engaging in strict scrutiny of everything that an executive does in the name of national security. I think that's wrong. But the only way to get that kind of deference regime is if the court is convinced that the executive is on the up and up and playing straight. because the last thing you want is the Korematsu world in which the executive is not playing straight, and yet the court picks up its standard rational basis deference kind of language. And so, that's my worry about Hawaii versus Trump. That's why I think it's so important that the records of that case be released soon, and not just the case, but of the kind of whatever paper there was leading up to that executive order.
From one hot button topic to another, I'm going to take us over to your role as a special prosecutor in the Derek Chauvin case. So I'm sure, as this audience likely knows, Chauvin is the former Minneapolis police officer implicated in the death of George Floyd. A jury convicted Chauvin of murder. He was then sentenced to 22 and a half years in prison. He has since filed a notice of appeal. So I wondered first, Neal, what you can tell us just about the role of a special prosecutor in general, like why does this happen? When does this happen? And then what specifically have you tried to bring to this case?
Yeah, so it's obviously an ongoing case, but the Chauvin case, which is now on appeal in the Minnesota Court of Appeals, and as well, we have the prosecution of the other 3 cops starting on March 8th of next year. And so I have to be much more circumspect. It's a criminal case. All these folks are entitled to the presumption of innocence and the like. So when I read about, or when I saw what happened to Floyd, can't remember if I read about it or saw the video first back on May 25th of last year, I was just so horrified and sad because I teach criminal law, and we talk about these issues, but that's what I've done in the past. I've talked about them. I've written a little bit, but I've never actually done anything. And I felt so guilty. And I was thinking about what to do. And it occurred to me that this trial is in a way like a lot of the things in my practice. About a third of my practice is helping other lawyers in their trials from an appellate perspective, like helping them frame the legal issues, write the dispositive motions and argue them, preserve issues for appeal, make sure the record is great, legal storytelling, and as well the communication side, to the extent there is any communication side. Obviously, it's different with respect to a criminal prosecution. We didn't talk to the media or anything like that, but just to understand how the media is processing something is important in the case. And so I reached out to the Attorney General, Keith Ellison, whom I didn't know, and I said, "Hey, would you be interested?" And he thought about it and said yes. And so my team of lawyers and I basically became part of the prosecution team. We were the prosecution team along with the Minnesota Attorney General's office, which is just phenomenal, crazy good lawyers. And as well, a couple of other special prosecutors who were true trial lawyers, unlike me, like it'd be malpractice to see me in trial. And together we worked on the case, and it was really, I've been privileged to work on all sorts of big legal teams, but this one was truly special. Everyone was just ego-free and really good, and we had different perspectives and different contributions. And so it was really an incredible experience to do. And also I would say to the Floyd family was just marvelous. And I found it really hard every time I had to see the video, and I probably have now seen it 100 times, many times just here in the privacy of my home office. But these folks had to see their loved one, had that happen to them in court almost every day during the trial. And just their resilience and dignity and strength. It was like, I can't tell you, it's like what a privilege it was to help them in any way achieve a modicum of justice. So anyway, we don't know what the appeals issues are yet. That I think they're going to be filing their appeal within, I think, about 60 days from now, and we'll see. But we're really really careful. We tried to be, that's one of the interesting things about this role as a prosecutor, as opposed to a like civil litigation, because you don't want to create an irreversible error that will ever undo the jury result. And so as a result, we were really careful not to ever push the envelope. Yes, there were things, and lots of people wanted us to do X or Y. And many of those were things that we thought, yeah, legally we could do X or Y, but we didn't do them because we didn't want to jeopardize in any way the jury verdict that we hoped we would get. And so we didn't push the envelope, but I thought we did ultimately do something really, really important: convict Derek Chauvin, a cop, of murder. That's an incredibly rare thing in the United States.
I think I can ask you one more question about this, while I think respecting your need to be circumspect about ongoing litigation. There is a federal civil rights case against Chauvin as well. And I wondered if you could say, whether you expect this to have any impact on the state appeal, and also more generally, what do you think is the importance of federal prosecutors pursuing cases like this, even where, as you said, a state prosecutor is actively and competently seeking justice?
Yeah, I'm not going to speak about that with respect to this case at all. I've certainly said before this case ever existed, publicly many times, that I think it's really important for the United States to play a role, because this is an offense absolutely against Minnesota, but it's also, or whatever crime that whatever state the crime happens to occur in. So it's always a state crime, but it's also a federal one, because our federal government stands for certain things. And one of them is that people should be treated equally and not subject to unreasonable force based on the color of their skin or some prejudice against them. And so I think it's really important for the United States always to step in these kinds of cases. Again, I'm not speaking of this case, but just in general, I think it is an important thing.
I'm going to bring us closer to home now. So those of us in Philadelphia are very grateful and proud of your representation of the city of Philadelphia in two matters. So City of Philadelphia versus Sessions, this is the 2017 Sanctuary City case, and more recently in Fulton versus City of Philadelphia. So in brief, this is the case about Catholic social services and their policy of not working with LGBTQ foster parents, which runs afoul of local anti-discrimination mandates. So the first question, and I'll maybe bundle these, is you presumably have a lot of discretion over the matters that you choose to take. So the first question is just, how did you establish this relationship with Philadelphia? And then the second question, more substantive, is I think, thematically, both of these cases implicate the power of local government to decide how it will treat members of marginalized communities. And I would say both of these cases also involved local government activity that clashed in some way with conservative preferences, sort of speaking with a broad brushstroke. So in the Sanctuary City case, it was clear that a conservative presidential administration wanted the city's cooperation in identifying and deporting unauthorized immigrants. And then in the Fulton case, there was an argument that religious liberty should essentially trump other governmental goals. So again, first question is about just how your representation of Philadelphia came to be. And then second is, in your mind, are these cases related, or does it really not make sense to think of them as sort of a package?
So I've always loved Philadelphia from the first time I visited, and on the teaching market back in 1996. I've come very close to teaching at Penn several times. I just love the school and I love the city. And one of the things I love about the city is the way that it treats marginalized groups. It calls itself the city of brotherly love, and it's truly about that. So in Fulton, for example, they had a non-discrimination ordinance on sexual orientation that goes back to the 1980s. At a time when, like I was in high school and heard all sorts of stuff, but the city was way ahead of its time. It added gender identity, I think 20 years ago, to its list of protected classes. With sanctuary cities, they were out in front right away. This was a city I wanted to work with. I loved that. And so I reached out to one of my partners in our Philadelphia office and said, could you introduce me? Could you help me? And she did. And that's how that relationship began. And it's really, one of the most moving things I got to do was work for the city in these two cases, and to strike down the sanctuary cities was just, a huge, big thing. And so much so that, it was, I think, written by a fairly conservative judge, Judge Sirica. And yet, we won, and the Solicitor General decided not to try and take that up to the Supreme Court. And with Fulton, I can't imagine in this day and age, and I'm very respectful towards people with religious views, but I can't imagine in this day and age that a government contract is a constitutional entitlement when you discriminate against LGBT folks. I mean, this was a case in which the city of Philadelphia for 30 years has been contracting out the screening of foster parents. And some newspaper writers discovered that two of these contractors discriminated against LGBT foster parents and said, we won't screen them. And so the city said to these two, hey, is that right? Is that what you're doing? And they said, yes. One of them backed down and said, we'll change our policy. The other one said, no, it's our constitutional right to discriminate against LGBT folks. And so the city said, well, you could do that, but then you're not going to get our contract for the foster care piece of it, the screening piece of it. We'll still give you other contracts on other stuff, but if you're performing city services and discriminating, we can't really have that with our own dollars, our city dollars. And they then sued, this one entity then sued the city, saying it's our constitutional right to be able to discriminate in government contracts. And that's the case that went to the Supreme Court. And this is a court that is particularly solicitous of religion in ways that I think are, probably going to be ultimately incoherent. Like, what are they going to do when a church in Texas says, abortion is a sacrament or something like that? I mean, they say we can't ever look behind a claim of religion and to determine like how bona fide it is and so on. So I do think that there's just a lot of there's so much deference to the religious claim by majority of this Supreme Court that I really worry, because it's in such fundamental tension with other precepts of our democracy. So in any event, that was one where at least the court took a narrow path in ruling against the city, basically just on the facts said, well, this is motivated by animus against religion, and therefore we're striking this particular policy down and not making any broader statement for the nation. I fundamentally, and I'm not just being Philadelphia's lawyer, I mean, having read the record, time and again, I think it's really hard to say that there was actually animus. I think that these city officials acted appropriately, but that'll be a debate that I think people will have for a long time. But I am worried about that. Now, I would say, in general, these two cases do have, to answer your last question, that theme, but so too does the case in which some of the left was mad at me for defending the Peace Cross in Maryland. That I've in some ways had different politics. This was a cross that had been around since I think 1919, erected to commemorate victims of World War I, and there are lots of crosses that are used as World War I markers all throughout America and Europe as well. And it had, in my view, a secular meaning. And folks challenged it. Great lawyer Monica Miller at the American Humanist Association challenged it, saying that it violated establishment rights and the like. And we came in to defend the city and the park planning, the local government agencies, and saying, no, this thing has been around for 100 years and has a secular meaning at this point. And I was really glad to see, I think the decision was 7-2, including Justices Kagan and Breyer siding with the majority and saying that this cross could stay. So I do think that there's a role for local government here. I think that's part of the wisdom of the founding design, which is to not concentrate power in any one place, to create some checks and balances. Sometimes that check occurs through separation of powers. Increasingly, as Congress gets more and more dysfunctional, it's got to occur in other places, and one place in which it occurs sometimes is local government.
I have one follow-up question about this, and this is actually coming from Susan Lin. And what I think the question is getting at is that, there have been, Fulton is a case in which it seemed like there was a lot of disagreement, depending on who you are and sort of what you're concerned about how to read that decision, right? With some people saying, this is the best we could have done, this is a victory, it could have been a lot worse. Other people thinking they're kind of reading the tea leaves and thinking this door is going to open, this decision kind of opens the door to something bigger and more dramatic. So what's your reaction to that? Do you view this decision as, the narrow compromise that doesn't have any particular meaning, or how would you read the tea leaves?
Yeah, I mean, I think it's probably hard for me to say since I'm Philadelphia's lawyer on this, but I would say, we haven't seen this decision being persuasively cited in any way to weaken the standard lines of cases. And so I think it was written in a very careful way, which is why it was unanimous. And so, at the same time, as Philadelphia's lawyer, I'm very upset with any insinuation that the city did anything wrong here, because I just don't think, as I was saying about the record, I just don't think that's supported by it. It's I'm sure, well, I'll just leave it at that.
Okay, I'm going to transition us to talking in general about, I think, a really tough topic, but I think you've had some important things to say about this. This will also be a chance for you, hopefully, to say a little bit more about some of the work that you managed to do on the side, in addition to everything else that you do. So the topic that I want to bring up is anti-Asian violence. And of course, a dramatic instance of this was the tragic shooting spree in Atlanta this past spring. It resulted in the death of multiple women of Asian heritage in multiple Asian operated businesses. And of course, I think we've also all read about COVID-related anti-Asian violence. So you produced a courtside episode where you spoke specifically about this issue, also hate crimes, also just generally about the impact of rhetoric and language that our elected officials choose to use. And so I wondered first if you could tell us more about the courtside series and why you spend your time producing these episodes, and also that episode specifically and what you hope to convey.
Yeah, so courtside was just something that I kind of threw together during the election crisis. And I just recorded one video on Instagram that kind of went viral about basically, an intro to the legal system and where things were going to go legally right after Trump started to make noises about challenging things like November, 10th or something. And then there was such a demand for it that I started doing them every day. I still don't know how I pulled it off, but I did it every day. And honestly, Karen, it ran me into the ground. And so I haven't done a courtside episode in, I think, 4 or 5 months now, because it was just so hard to do every day. I felt a real need to do it through January, through the inauguration, through the January 20th. But afterwards, I started to move away and from it, because I was, first of all, the election, was over, except for, those people who think that Trump's still going to be installed as president or something tomorrow. But, and so I started to do some other issues. And now I just try to do a little bit more of that on MSNBC and less with trying to, produce something myself, which was not easy. But maybe I'll pick it up again, who knows? But the hate crime stuff was, and still is, incredibly important to me. In part, one of the things I talked about in that episode was how I had, even in my own life, kind of repressed some of the incidents that I'd seen. I mean, I remember like one very vivid time. I was about 5 years old, and my mom was backing up her car out of the driveway, and someone just, who was flying by in the street almost hit her. And then that woman ran out and said, and started yelling at my mom and saying, you should go back to your country and stuff like that. And just all sorts of horrible stuff. And, I think the way we grew up was just ignore it all, just swallow it. Don't let it affect you. And it did, in many ways it didn't, through that kind of repression strategy. But particularly when all of these incidents started unfolding, and I had a similar reaction. I remember after 9/11, when some Sikhs were murdered, that I do want to talk about, I do want to do something here. I do think that, the idea that we don't really have real strong federal legislation on this is a real travesty. The idea that we don't have federal enforcement, again, picking up on your question earlier about prosecution of civil rights cases at the federal level, I think it's so important. Obviously, the Trump DOJ did none of this, and indeed, Trump himself fomented a lot of this with all his talk of China virus and all sorts of nonsense like that. And so, one of the things I really do hope the Biden administration does is care about this issue, and not like just as like some sort of political point to get the Asian American community. This is not a political thing. This is like, fundamentally what the fabric of this country is. And I worry that, the signal that we've been sending to the rest of the world is kind of that we are racially divided in ways, that are really destructive. And like someone like my parents trying to decide whether to come to America now, I think we lose some of those people because they don't want to come when they see these images and and obviously it's only a small thing. It's a tiny percentage of the American population, but it's one that has an outsized kind of representational effect worldwide. And so I really, really hope that the Justice Department steps this up.
So I want to be mindful of your time, but I think we have time for one more question. And I realize this might be a hard one, but this is one that I think about a lot. Some of the issues that you work on, whether it's, anti-Asian bias or the way that claims of, executive branch privilege affect marginalized groups. They seem so big, and it can feel dispiriting, especially when we think about, just the deep histories of animus and exclusion in this country. And, I think I also come from a background of, let's keep your head down, do your work and, not get in the middle of things. Like lawyers, I think, are kind of by nature maybe more conservative or more cautious. So do you have any suggestions for this audience in particular about, just what you could do in your everyday life if you care about these issues and you want to do more than kind of just, again, keep your head down?
Yeah. So, first of all, I really do believe you can't keep your head down now. It's just, if January 6th didn't convince you, if the attacks in Atlanta didn't convince you, I don't know what would. It kind of, our profession, it's not a political thing at all. Our profession is based on respect for the rule of law. That's our job, is to defend it. And it's really under attack. And it's under attack on voting. And it's under attack on these other issues we've been talking about all throughout. And so I do feel like people need to do stuff. Part of it is just calling people out when some of this stuff happens. And I know that's scary and uncomfortable. And part of it is representation, it's not that resource intensive to go and try and protect one of these victims who, bring a civil lawsuit against someone. We're working with, different groups to try and on voting rights, try and do that. Even just, voting for candidates in state legislatures that aren't going to gerrymander unfairly, just, micro things too. And then I do think I think that those of us who've seen this stuff firsthand, I think have an obligation to talk about it, even as hard as it is. And I don't mean to basically everyone be crying victim all the time or anything like that, but I am saying we've seen and witnessed a lot, and people don't know that. People think that this is, non-existent. And that's what Trump said after, I think, Atlanta. And it's real. And so I think talking about it is really important. It'll remove some of the poison from society, just mere talk, particularly coming from, lawyers, that, kind of a key profession in this kind of way to make a more perfect union.
Well, I think we should stop there, again, to be mindful of your time. But I want to quickly note for the group that you have a Twitter account. You have a great website where folks can see links to your writings, to your media appearances. I think, do you also have oral arguments linked there and other things about the cases that you're working on?
Yep.
So anyway, check out the website. It's really terrific. And Neal, just thank you so much for taking the time to talk with us. This was really, really enlightening and really insightful.
Oh, well, thank you. Thank you for such great questions. And thank you all in the audience for listening to me drone on. And thank you, Susan, and everyone for the invitation.
All right, so as we say goodbye to Neal, I have the privilege of saying a little bit more about one of the really important matters that Neal mentioned in his comments. So I'm going to take just a few minutes to elaborate on the significance of the confession of error that he and I referred to earlier. So this was the situation in which Neal Katyal, who was at the time acting Solicitor General, he apologized on behalf of the Department of Justice for its role in justifying the mass evacuation and confinement of Japanese Americans during World War II. So I'll just read very briefly an excerpt of his statement, and then I'll give some further context. So this was from May 20th, 2011. He wrote, there are several terrific accounts of the roles that Solicitor Generals have played throughout history in advancing civil rights, but it is also important to remember the mistakes. One episode of particular relevance to AAPI Heritage Month is the Solicitor General's defense of the forced relocation and internment of Japanese Americans during World War II. Following the attack on Pearl Harbor, the United States uprooted more than 100,000 people of Japanese descent, most of them American citizens, and confined them in internment camps. The Solicitor General was largely responsible for the defense of those policies. So I'll pause here to offer, again, some additional context, and this is an elaboration of some of the cases that Neal mentioned. So you might recall that the Supreme Court had several opportunities to rule on the legality of the government's treatment of Japanese Americans during war. So there was the criminal appeal of Gordon Hirabayashi, also the criminal appeal of Fred Korematsu. So both of these men were prosecuted for violating different internment-related orders. There was also, I think, an under-recognized habeas petition by an internee named Mitsuye Endo. So Katyal's statement explains that by the time these cases reached the Supreme Court, the Solicitor General was in possession of some pretty damning evidence against the Roosevelt administration's position. So there was, for example, a key intelligence report that went into detail saying that the vast majority of Japanese Americans posed no security threat. Recall that this was a key rationale for the internment. It further found that those who did pose a threat, that small number, were already known to the government or in government custody. The Solicitor General did not inform the court of this report, despite warnings, and again, Neal mentioned these, that failing to do so might, quote, approximate the suppression of evidence. There were also some reports with similar findings from the FBI, from the FCC, and again, Solicitor General did not turn over or acknowledge that evidence. Instead, he drew on racialized stereotypes to argue that it was practically impossible to segregate loyal Japanese Americans from disloyal ones. Now, had the Solicitor General acted differently, I mean, we don't know exactly what would have happened, but I think it's fair to say that perhaps the Supreme Court would not have upheld Hirabayashi's and Korematsu's convictions in 1943 and 1944, respectively. And perhaps it would have taken a different approach in that habeas case that I mentioned from Mitsuye Endo, which was decided the same day as Korematsu. I'll say a few more words about the Endo case. Again, I think this is really historically significant. So in that case, the court, in one sense, did the right thing. So it unanimously held that the federal government could not indefinitely detain US citizens who are concededly loyal. And thus, in doing that, it belatedly made clear that the camps would have to be emptied out. But the court reached that holding via a path that was hardly admirable. So rather than address head on the constitutionality of the mass confinement of Japanese Americans, the court essentially skirted the issue. So it framed this mass confinement as basically the policy decision of a rogue agency, acting outside the scope of the relevant executive order, outside the scope of the relevant statute. It was as if neither President Roosevelt nor Congress had ever contemplated internment, which clearly they did. So in other words, the court's decision in Endo basically allowed everyone but this poor agency, the War Relocation Authority, to emerge from this whole thing with pretty much clean hands. Not until the 1980s did Gordon Hirabayashi and Fred Korematsu have their convictions overturned. I'm referring here to the Coram Nobis proceedings that Neal mentioned. In 1988, surviving internees also received an apology and the promise of modest reparations from the federal government. But in the meantime, I would say, a lot of damage was done, and it is not the kind of damage that money can easily repair. So, for example, some people, were so mistreated and disgusted that they renounced their American citizenship, went back to Japan. People lost homes, they lost businesses, family networks fractured. There was a long-standing culture of fear and of silence. I'll give you a personal example. So I'll tell you briefly about my grandma Yoshi, who, in one sense, her internment was, a key part of her personal journey. And it was a blessing in the sense that she met her husband in the Minidoka internment camp. And, they went on to live a joyous, beautiful life. But she clearly also felt a really deep sense of betrayal by the American government, like this enduring suspicion. It was from her that I learned this quote from Charles Evan Hughes. The quote is from before Hughes' time on the Supreme Court and from well before the internment. But for my grandma, she always, whenever she talked about the internment, which she did sort of in the 90s, she finally started talking about, she would always close her talk with this quote. So I'll read it to you. Hughes said, "You may think that the Constitution is your security. It is nothing but a bit of paper. You may think that statutes are your security. They are nothing but words in a book. You may think that elaborate mechanism of government is your security. It is nothing at all unless you have sound and uncorrupted public opinion to give life to your Constitution, to give vitality to your statutes, to make efficient your government machinery." So those words, I think, are in one sense a call to the public to pay attention and to get educated and, to do their civic duty as citizens. And I think all of that, good stuff my grandma believed, but these words are also a warning. And I think she invoked them in that spirit as well, right? Like those constitutional rights that you supposedly have, they are not self-executing. Those government officials who are supposed to have your back, they may not. So I'll return now to Neal Katyal's words in that confession of error. So this is continuing from his statement. "Today, our office takes this history as an important reminder that the special credence the Solicitor General enjoys before the Supreme Court requires great responsibility and a duty of absolute candor in our representations to the court. Only then can we fulfill our responsibility to defend the United States and its Constitution and to protect the rights of all Americans." I would say what is especially meaningful to me about this statement is the aspiration and really the insistence that government lawyers be better. That even if their job is to defend the decisions of a particular political administration, even if their job is, as Neal said, to make sure that the executive branch retains the discretion and the power to protect national security, they also have a duty to the broader public. The public should be able to trust, as Hughes put it, the mechanism of government, and government lawyers are really crucial to that mechanism. I think there is more to say here. So there are certainly historians have identified government lawyers other than the Solicitor General who also played really shameful, disturbing roles in the Japanese American internment. So, stay tuned. I think the reckoning here is ongoing. For those who are interested just in this particular topic, I would refer you to my colleague Amanda Tyler's book on habeas corpus in wartime. She has a really excellent chapter on this. Also, Peter Irons's very classic book, Justice at War. But, for this occasion, I think the appropriate posture is just gratitude to lawyers like Neal Katyal, who are interested in history, who think about the symbolic power of legal precedents, and who take the ethics of lawyering really seriously. So I think in closing, he was just an excellent choice for the keynote for this occasion. I'm very, very grateful for the opportunity to have been in dialogue with him. So thank you so much, and I will now transition back to Susan.
Karen, thank you so much for closing with such incredibly wise and insightful remarks. Thank you for guiding us through a fascinating conversation with Neal. And thank you for sharing a little bit of your personal family history and the words of wisdom that your grandmother has passed on to others, and now you have been able to share with us. We are also incredibly grateful to Neal Katyal for taking time out of his busy schedule to share his own work and his own thoughts about work with us. For folks who want CLE credit, we are going to start a poll now. Please respond to the poll. It shows that you are here, and therefore we can submit your information for credit. We're going to let this poll sort of be for a while. You must respond in order to get CLE credit. The other thing that I want to remind folks of is that this is a fundraiser for APABA-PA, as well as for the Marutani Fellowship. We are about to go on to the presentation for the Marutani Fellowship, but I would refer everyone to our chat function. In there are two web links. One allows you to donate directly to APABA-PA to support both our programming as well as the fellowship. The other one allows you to donate directly to the Marutani Fund, which is held by and run by the Philadelphia Bar Foundation. Shout out to the Philadelphia Bar Foundation. Thank you very much for your support in that. With that, I am going to leave the poll up for a while, but I would like to turn things over to John Yee for presentation of the Marutani Fellowship Award.
Thanks, Susan. Always fun to, I guess, compete with an attendance poll, but I'd like to, I guess, go ahead and get started and say this is, I don't know, maybe the third or fourth year that I've had the privilege and the opportunity to kind of stand or share a screen with everyone here. And it's always a pleasure to have an opportunity to really just spotlight and increase awareness for Judge Marutani's legacy, particularly with today and the speakers that we've had and the topics that we've discussed. As many of you know, Judge Marutani was confined in an internment camp for a period of some time in World War II. From there, he actually served in the military. He went on to have a storied career in the law as an attorney, as a civil rights advocate, as a leader both at the local and national level of the Japanese American Citizens League, and also as a jurist. And, it's kind of, I got to know kind of the legacy of Judge Marutani when I was in law school, applying for this particular fellowship. And it's certainly a privilege to work on this committee and award the fellowship to law students year in, year out. And we have two phenomenal law students I'd like to introduce you to. But before I do that, I do want to thank a few people. Actually, I want to thank a lot of people. So one, I want to thank everyone here in attendance. As Rich noted, your attendance directly supports the fellowship. And as Susan noted as well, your continued support is greatly appreciated. And then second, I wanted to thank the committee too, the fellowship committee. Wonderful people who put in the time to vet a number of applications, a number of which grows each year, and applicants who are each year are more and more impressive. And also want to highlight the Philadelphia Bar Foundation for their support as well on the committee, as well as kind of just running the donations and the fund. And with that, I'd like to introduce our two fellowship recipients. You can see them on your screen. We have Livia Luan, who is currently a 2L at Temple. Livia spent her I guess, just recent summer as an immigration rights intern at the ACLU. And we also have Tway Ho, who is currently a 3L at, yep, you guys are both ways, who is currently a 3L at Rutgers Camden. Tway spent this past summer as an intern at the Amistad Law Project, which is a civil rights organization for prisoner advocacy. And I believe Tway spent last summer also at the ACLU. I've had an opportunity to get to know both this past summer, and actually look forward to continuing to grow that relationship moving forward. So if you'd like to read more and learn more about their summer internship experiences, you can see these wonderful essays that they've written on the Philadelphia Bar Foundation website in the Marutani section. And then from there, moving on to the next portion of our program, I'd like to turn it over to Rahat for the Attorney of the Year presentation.
Great, thank you, John. Hi everyone, good afternoon. I am honored to introduce APABA-PA's 2021 Attorney of the Year Award, Ming. First, a quick background on this award. Under the leadership of a former APABA-PA president, Joe Centeno, APABA-PA's Leadership Advisory Council proposed the creation of the Attorney of the Year Award in 2014. That year, as many of you will recall, APABA-PA celebrated its 30th anniversary, a moment where we reflected on our organization's rich history and accomplishments. And as I recall the conversations then, I distinctly remember one common theme. The time had long arrived where we, APABA-PA, should publicly recognize the incredible contributions and achievements of our members. So, starting in 2014, we honored our first set of luminaries, Shu and Law, Dennis Morikawa, both living legends in their own right. In the years that followed, drawing from APABA-PA's deep bench of accomplished changemakers, we honored Suzanne Young, the Honorable Stella Tsai, John Chu, Kei Yu, Glenn Hing, and then last year, Paul Urahara. So today, I am thrilled that we will add my friend, Ming to that role of honorees. A passionate advocate and a proven leader, Ming exemplifies the best of our community. Ming is currently the executive director of the Pennsylvania Institutional Law Project, where she works to safeguard the rights of one of the most vulnerable communities in our society through legal representation and advocacy. A trailblazer, Ming is the first and only Asian American who has served as an executive director of an organization within the Pennsylvania Legal Aid Network. And since joining the Pennsylvania Institutional Law Project in 2006, Ming has engaged in cutting-edge litigation on behalf of her clients. For example, she obtained a presidential court ruling that confirmed that immigration detainees, which seems self-evident, are entitled to constitutional rights. Ming also handled a successful class action lawsuit that led to over 5,000 incarcerated individuals in Pennsylvania to receive life-saving hepatitis C treatment. Outside of the Pennsylvania Institutional Law Project, so many of us in this Zoom room are familiar with her leadership. Just to name a few examples, she has served as APABA-PA's president in 2015, an adjunct professor at Penn Law, a board member of the Defender Association, and a former co-chair of Philadelphia Bar Association's Civil Rights Committee and the Public Interest Section. On a personal note, over the years, I have worked closely with Ming, especially during our time as APABA-PA officers many years ago. Both personally and professionally, I have long come to rely on her counsel and sound judgment. You spend any amount of time with Ming, and you can't help but notice her deep dedication and commitment to our community, and the compassion that she brings to the task at hand, while simultaneously juggling any number of competing obligations. So for these reasons and many, many more, please join me in honoring Ming as APABA-PA's 2021 Attorney of the Year. Ming.
Thank you so much, Rahat, for those incredibly kind words. I am so touched and humbled to receive this award from APABA-PA. And really, this is just so special. It's a recognition amongst peers, colleagues, but also friends. APABA-PA has been so critical in addressing many challenging issues affecting the Asian American community, but it also has created a sense of home for me in the Pennsylvania legal community, and I've been a proud member ever since I've become an attorney. So my Asian American identity has been fundamental in what motivates me as a public interest and civil rights lawyer. Growing up as an Asian American, similar to what Neal Katyal mentioned, I got comments like, "Oh, you speak English so well," or "Where are you from?" or "Where are you really from?" Or "Go back to China." I had one teacher who said my name was too difficult to pronounce, and she was going to call me Susie Cusey, which she did the entire year. And worse, I've also encountered derogatory names or racial slurs. And many of you have experienced similar experiences. I have a really strong memory as a child being asked by a teacher, "Are you Chinese or are you American?" And I remember going home and asking my mother, who I believe is on today, whether I was Chinese or whether I was American. And she explained that I was both. Neither one or the other, but really both. And I think that was the seed of my Asian American identity. And so I really value my parents instilling a strong sense of my own identity. Both of them are immigrants, arriving to this country through long journeys and large freight ships. I learned that my mother and her family had faced discrimination in trying to find apartments or housing in New York City while they were living there. And when she applied to medical school, they had quotas, only allowing in one Asian American woman and one Asian American man each year. Yet at the same time, despite the challenges we face as Asian Americans, they did instill with me a sense of that I'm so lucky and fortunate to be where I am today. That maybe in another time, in another place, I wouldn't have this opportunity to have a great education. I mean, look at me now. I got to go to law school. I'm a lawyer. What incredible privileges. So just as I stand on the shoulders of those who came before me, I think I've sought my life to try to use my privilege to pave the way for the others. So some of you know, after college, I had this crazy or sort of unusual idea that I wanted to go to another country and be a US Peace Corps volunteer. So I went to the Kingdom of Tonga. I was young and enthusiastic. And there I was living on a tropical island, palm trees, soft blue waters, all the coconuts. And I was so excited. I was going to change the world. I was walking around in one of the early days, and all of a sudden, you feel the eyes on you. And some children started pointing their fingers at me and running after me, yelling, "Siapani, Siapani," which I later learned means Japanese. And so I felt very confused, offended, self-conscious. And I found out that I was not their typical US Peace Corps volunteer. I didn't fit their idea because I wasn't white. But over the 2 years, experiencing the day-to-day joys and challenges of being a middle school and high school teacher, I had a lot of opportunities to engage in cross-cultural dialogue. And I remember later, one of my Tongan friends kind of defending me, telling a new teacher that I was not Japanese, but actually my family's Chinese, but I lived in the United States and I was a Peace Corps volunteer. So all those experiences set me on a path towards a career in social justice. And returning, I worked in a number of different Asian American nonprofit organizations before applying to law school. And my focus today, as I talk, is on my Asian American identity, but the intersectionality of my various identities all shape who I am and really are a source of resilience and perseverance, where I work at the Pennsylvania Institutional Law Project, representing people who are incarcerated and detained on their constitutional and civil rights claims. So at the Institutional Law Project, the majority of our clients are Black or Brown and have experienced systemic racism, discrimination, even before becoming our clients. While they are incarcerated, many of our clients have suffered unfathomable abuses, live in unsafe and inhumane conditions, suffer from the severe lack of medical care. And my experiences, whether it's my racial or ethnic identity or other identities, really serves as a basis to drive me to be the best advocate on their behalf and to do everything I can now as the leader of the organization to create positive and systemic change. And I feel really privileged to work for an organization that confronts injustice head on. And I'll note that the Pennsylvania Institutional Law Project is now celebrating its 40th anniversary, and we're holding a virtual event tomorrow evening at 6 o'clock to celebrate, and I invite you to join us. I want to thank all of those who have supported me through my life and career. Thank you to my parents, my sister, my extended family, including my aunts and uncles and cousins who might be on today, who are on today, my mentors, friends, the colleagues and staff, and also my co-parent and daughter. I'm so grateful for all of your support. And last, even though I no longer am in those days where I walk down the streets and people are pointing to me on a daily basis, there are often times when I suddenly realize, a moment of self-consciousness, that I'm the only one of my type in the room. So in the area of civil rights, especially on behalf of people who are incarcerated, I'm often the only Asian American in the courtroom. And I think that spurs me to do even better, to apply my skills, to do everything I can for a better shot at justice for our clients and for those who otherwise might have no voice. In the last year and a half, we together have experienced incredibly challenging times, from the COVID-19 pandemic to a greater awareness of systemic racism, Black Lives Matter, and of course, most personal, a greater awareness of anti-Asian violence and the Stop Anti-Asian Hate movement. Every voice counts and every person's actions make a difference, large and small. And I think we really learned that in the last year and a half. Whether learning more about an issue, doing pro bono work, even making a donation, voting in every election, making a call to your elected representatives, reaching out to someone in need, or just being engaged in community dialogue and being aware of what is going on. It all matters. And a lot of times people do ask me, how can I help? Even if I can't, take on a case, how can I help? And these are all things that are vitally important. So I ask you to join me in whatever way you can to look for opportunities to make our community and our world a better place. And I have hope organizations like APABA-PA who actively work towards equity and justice give me and many others hope. So I am proud to be a longtime member of APABA-PA and incredibly honored to receive this award.
I hope everyone is applauding in their own office room, wherever they're coming from. It is such a pleasure to see Ming get this very well-deserved award. And it was such a pleasure today to see all of you attendees, the list of all of your names here, that you could join us in hearing words of wisdom from both Neal Katyal, from Karen Tani. It has been a wonderful event. I would not be doing my job if I did not plug one more time the ability of all attendees to make donations to both APABA-PA to support this programming, as well as the Marutani Fellowship Fund. Instructions are posted in the chat. I would also like to take this time to thank our main sponsor, Comcast, who has been incredibly generous and has a history of supporting diverse communities throughout this area. I'd also like to thank our gold sponsor, PICO. I'd like to thank all of our sponsors who have generously supported us. They are listed on our website. They were listed on our PowerPoint today leading up to this event. I wish we were in person. I wish that we had the capacity to see each other and to mingle. Sadly, one of the restrictions of a COVID era event is that we cannot do so here. But I invite all of you to attend future APABA-PA events. We'll have a chance to see each other. We'll have a chance to hug each other. And we'll have a chance, hopefully, to work together in doing and meeting the calls of Neal and Ming and Karen to do more, to keep our head up, to not keep our head down, and to try and improve this great country that we live in. Thank you all, and I hope you have a great rest of your day. And donate. Thank you.